You are watching PR English Shorthand Dictations YouTube channel.
This is English Shorthand dictation number 406 and the dictation speed is 100 words per minute. Ready? Start. The Learned Council, appearing for the City Montessori School, has taken us through the relevant documents. He also pointed out that the plot in dispute is a garden plot, which is adjacent to the land held by the school. He pointed out that the High Court has not accepted that the bid offered by the school could have been cancelled on the ground that the school purchased the tender document on the last date. The Learned Council submitted that the order dated 6th December 2000, passed by the Allahabad High Court in the appeal filed by the alleged lessee against dismissal of his suit, is a collusive order. He submitted that the trial court decided all issues framed against the alleged lessee except the issue of his possession. The Learned Counsel urged that the lease claimed by the alleged lessee is not in subsistence. He pointed out that the alleged lessee is a defaulter who has not paid rent for a long time. He submitted that in any case, the original lessee could not have transferred the leasehold rights regarding the plot to the alleged lessee. The Learned Council therefore submitted that, firstly, the order of cancellation of the highest bid offered by the school was bad in law. Secondly, during the pendency of the writ petition, the authority had no right to consider the prayer made by the alleged lessee for conversion. He submitted that the conversion order and consequent deed executed in favor of the alleged lessee are entirely illegal. He would therefore submit that the order of acceptance of the bid offered by the school be passed. The Learned Counsel, representing the alleged lessee and his sons, submitted that the order of conversion was passed in favor of the alleged lessee in terms of the prevailing policy of the state government, and there is nothing illegal about the same. He submitted that the deed executed based on the order of conversion is legal and valid. He submitted that the school belatedly made the application for amendment of the writ petition for challenging the conversion and for the sale deed, which was never allowed. Therefore, the High Court committed gross illegality by setting aside the order of conversion and the sale deed executed by the authority in favor of the alleged lessee. He submitted that there was a delay on the part of the school in purchasing the tender document, and as the same was purchased after the expiry of the outer limit provided in the tender notice, the school's bid could not have been accepted. He urged that, as the alleged lessee has been in possession for decades, the conversion order cannot be faulted. The Learned Counsel, representing the state government, stated that the present legal position is that such leasehold plots cannot be converted to freehold and cannot be auctioned. In the facts of the case, there is no dispute that the plot vests in the state. Even assuming that the alleged lessee has leasehold rights concerning the plot, the rights of the state as the owner and lessor cannot be transferred only by adopting a fair and transparent process by which the state fetches the best possible price. In case of sale of a leasehold plot by the lessor, the rights of the lawful lessees do not get affected as their tenancy will be attorned to the purchaser in view of section 109 of the Transfer of Property Act 1882. Therefore, the rights of the state as the lessor can only be sold by a public auction or by any other transparent method by which, apart from the lessee, others too get a right to submit their offer. Selling the plot to its alleged lessee at a nominal price will not be a fair and transparent method at all. It will be arbitrary and violative of Article 14 of the Constitution of India. There is a controversy raised by the alleged lessee about whether the application to amend the writ petition made by the school to incorporate the challenge to the conversion and the deed was allowed. However, on page 12 of the impugned judgment, the High Court recorded the submission of the learned counsel for the alleged lessee that there was a delay on the part of the school in challenging the order of conversion. The submissions recorded in the impugned judgment show that the parties proceeded on the footing that there was a challenge to the conversion order. The counter filed by the alleged lessee before the High Court shows that it refers to the amended writ petition, and paragraph 45 of the counter raises a contention of the delay in challenging the conversion deed. Therefore, the argument that the amendment was not allowed need not detain us. Coming back to the facts of the case, the plot was put to auction in 1995. The special Nazul officer accepted the highest bid offered by the school of 8,50,000 rupees, out of which a sum of 85,000 rupees was paid along with the tender. We have already stated the facts leading to the cancellation of the highest bid of the school and acceptance of the second highest bid of the sons of the alleged lessee. It is important to note that the special Nazul officer passed an order on 26th November 2001 by which the consideration for converting leasehold rights into freehold rights was fixed at 67,000 rupees. This amount was less than 10% of the bid offered by the school about 16 years before the order dated 26th November 2001. On the face of it, this cannot be a fair and transparent process of transferring the state's ownership rights. We have perused the judgment of the civil court dated 24th July 2000, which dismissed the suit filed by the alleged lessee. The trial court held that the alleged lessee was not entitled to the benefits of government orders dated 17th February 1996 and 1st December 1998. In the suit, the alleged lessee sought conversion from leasehold to freehold based on these two government orders. All findings were recorded against the alleged lessee except the finding that he was in possession of the plot. Being aggrieved by the decree of dismissal of the suit, the alleged lessee preferred first appeal number 81 of 2000. The appeal was disposed of by the order dated 6th December 2000. The High Court heard the counsel for the alleged lessee, the authority, and the state government. The first paragraph refers to the appearances of the learned counsel.